But it's an issue. I just draw it to the Minister's attention. We'll be voting against it anyway.
Mr.
The Honourable Dr. Nick Smith.
I am happy to provide an explanation, and can I acknowledge the work of both Maggie Barry and the Department of Conservation in developing these more practical provisions for dealing with concession applications. And I think it's important to firstly understand and explain for the member from New Zealand First question, and that is, at the moment, when a concession application is received by the Department of Conservation, the Minister has to make a decision as to whether they intend to grant the concession. And that causes huge confusion, and the member may well recall the controversy when I was privileged to be Minister of Conservation around both the tunnel proposal and in respect of the monorail proposal. Now, that creates quite a difficult confusion because it's as though the government wants to favour. Now, what we do want to have is, and members like Eugene have been absolutely correct in saying these lands are primarily there for conservation purposes. The Minister of Conservation has got a really important role to protect that. And so what is being provided in the improved process in Section 17SB is before an application is even notified, the Department and the Minister is able to say, nah, I'm not even prepared to consider that. I don't want to publicly notify. It is obvious that it is inconsistent with the purposes with what that land solves. In other words, it is saying it is so out of left field that we just want to say no at the beginning. And I think that's a reasonable provision. These are public lands and for that purpose. Now, the second question has been asked around the timeframes and the 40-day, 20-day. The challenge I have for members opposed to this provision is why is it any different to the Resource Management Act? Whether it be for mining or whether it be substantive activities, if the arguments that Mr Parker wants to put forward that says that you've got community conservation organisations that are concerned, or what about a major mining proposal that has big impacts on the quality of water? That's a public resource, equally important as our conservation land. What the government is saying is both in terms of the notification period, the 20 working days, and what is provided for in this part around the Christmas break period, is to make the provisions exactly the same around conservation concessions as they are in the RMA. If members of the Labor Party and other opposition members want to argue that these timeframes are wrong, I would put to them they should also change the RMA, because you can have massive multi-billion-dollar projects, huge impacts on public resources, on coastal space, all sorts of things, and I just think there's a really sensible argument for those to be consistent. The third point I would make about these provisions is actually a real problem for ministers of conservation, when certainly I was there and previously, is that people can lodge applications for concessions with minimal information requirements. And I do draw members' attention to this part that substantially boosts the Department of Conservation's requirement that if you want to apply for a concession on public land, you have to provide a lot more better quality information for that concession, even before the clocks start ticking and they being publicly notified, and that I think is a substantial improvement in the way in which we manage concessions on public land.
Robertson.
Mr Chair, I actually wasn't going to take a call on this.